Thanks, Jaden, for the introduction. Good evening, everyone. Thanks for joining us at this presentation. This is actually our second year of participation at Vancouver Startup Week, and we're excited to still be able to connect with all of you virtually this year. So I guess we could get started with the introductory remarks. I first wanted to introduce myself and my colleague here. So first of all, my name is Anand Athiviraham, and I'm a corporate lawyer at Watson Goepel. I have a few specialty practice areas, one of them being technology law. And as a founder of an e-commerce startup myself over 16 years ago, I went into law after realizing my journey could help other entrepreneurs in getting their legal affairs in order. I've been a lawyer for more than 8 years and also operate our firm's office out in Surrey. So I have a lot of experience assisting clients with issues relating to their business, some of which we'll be covering today. I'll now turn it over to my colleague, Cameron, to introduce himself.
Thanks, Anand. My name is Cameron Funnell. I'm a lawyer here at Watson Goepel. I've been here for about 3.5 years, and before that I was practicing in an intellectual property boutique. So I still do some IP work, but I also do a reasonable amount of corporate commercial work, helping small businesses from the very beginning stages up until when they've scaled up. Back to you, Anand.
All right, thanks, Cam. So as our time is limited tonight, we thought we'd pick 3 important topics for us to cover. And it should help any existing entrepreneur or new entrepreneur or startup with running their business properly from the get-go. And if you're growing, then maybe things to think about while you're in that growth stage. Now, if you have any questions during our presentation, please do use the chat box here, and we'll do our best to answer most of them at our presentation. Otherwise, we'll try and cover some of them during our presentation as well. So the first topic I'll be covering today is about the kinds of agreements that every startup needs. Secondly, my colleague Cameron will be covering how to best protect your intellectual property. And we'll end off with some guidance and tips on choosing the right legal advisor for your business. So without further ado, let's talk about agreements. Agreements should be the cornerstone of every business, as they're what govern the terms and conditions of your whole operation. This is why I'd like to start with something I often explain to potential clients, which is this: spending some money now to draft a proper agreement will save your business from potentially incurring tens of thousands in costs later. And my practice involves often helping and advising a variety of businesses on what types of agreements they need tailored for their needs, and to help prioritize certain agreements over others to ensure expectations and budgetary concerns are met. Now, ideally, every startup would want to make sure all their legal bases are covered, but a lot of you are probably bootstrapping and costs are limited. So while I'm talking about some of these agreements, I'll try and highlight when I often recommend to enter into these types of agreements. And if you have any further questions, feel free to ask again. So a shareholders agreement is really critical because any business that's involving 2 or more owners should get advice on drafting a shareholders agreement as soon as possible. At the time of incorporation is preferred. I'll be going a little bit more into what's sort of contained in a shareholders agreement in the next slide, but I wanted to point out that a shareholders agreement is sort of the key agreement when you have more than one individual, and often is overlooked. So it is something that you should prioritize early on.
And I just jump in there. I'm sure you've seen lots of cases where people have ended up into disputes because they don't have a shareholders agreement. And it's not an exaggeration to say that it can cost you tens of thousands just in legal fees, let alone the disruption to the business. So if you're going into business with more than one person, you might feel that everything's going well and you trust each other. But I think it's really a mistake to proceed without a shareholders agreement in place. That's, I think, absolutely key.
Absolutely, and there's often a honeymoon period between the founders, where everything seems to be going well. But we've seen both Cameron and I in both our practices that when things get messy, that's when it gets really, really difficult to negotiate, and you'd be at a disadvantage definitely for your business and your prospects if there's this dispute that's looming over your whole operation. So it is something you want to sort of early on. The next thing I want to talk about is a non-disclosure agreement, or confidentiality agreement as it's known. This type of agreement is important before you communicate with any suppliers or investors who may be hearing about the core secrets and data about the business. Without an NDA, there's no inherent obligation for parties in the for parties who are talking about the business to protect or maintain confidentiality of the information received, leaving little recourse to your business if you inadvertently disclose it without having this agreement in place. So the confidentiality agreement is something that you want to make sure that, before you disclose your secret sauce or anything that's relevant that pertains to your business, that, the other side understands its obligations to maintain the confidentiality. And if there's any issues with that, you don't disclose anything. So that's usually a good rule of thumb. The next thing I want to talk about is terms of service and privacy policy. So these agreements often go together because a terms of service usually found on a website, and it can identify key sales terms. For example, refund policies, sale policies, order policies, etc. While the privacy policy gives a visitor notice on how their information, whether through the use of forms or cookies placed on the end user's browser, how that's collected and handled. And this is especially important for a business engaging in online commerce to comply with laws such as the Canada Anti-Spam legislation, or CASL for short. Cam, do you want to say a couple of words about that? Or?
Yeah, this came into effect a couple of years ago. Canada's anti-spam legislation, CASL. It imposes pretty onerous requirements on any business that's sending out any type of commercial electronic message, which includes email. So it's important to be familiar with those rules and comply with them if you are planning on sending any type of marketing or advertising communications. They're a lot stricter than you might assume, and I think that a lot of startups might be running foul of these rules without knowing it.
That's right. And so the next, if you have any questions, again, feel free to ask. But the next agreement I want to just mention here is a service agreement. A services agreement often contains a statement of work, which is essential in situations where you're engaging a third party to build or design something for your business, or vice versa. Without one, you're essentially risking conflict, the inability to get out of certain sticky situations, and opening your business to liability and cost overruns. So really, you want to make sure that you're doing that very clearly early on. And the key thing to remember about a services agreement is you don't want to just gloss over the key terms. You want to make sure that it's very clear. For example, pricing terms, the deliverables, intellectual property rights. So it's a pretty comprehensive document, depending on the complexity of the operation, but it is important to put in place as soon as possible. The next thing I want to emphasize here are employment agreements, as well as independent contractor agreements. So any business hiring an employee or engaging the services of an independent contractor, and you might know an independent contractor, in the tech lingo, it's often you refer to them as a freelancer. So if you require them to be hired, then you should get everyone to sign an appropriate document that sets out the key terms for those individuals. With respect to employees specifically, this protects the business not only from potentially incurring thousands of dollars in unforeseen severance obligations, should the employee be terminated in the future, but also make sure that any intellectual property that they've developed through the course of the employment are essentially the employer's, right? Because the last thing you want is for the employee to have developed something that was really important for the business. Suddenly they leave their employment, and now you're stuck without having the full intellectual property rights to whatever they created during the course of their employment. So an employment agreement is somewhere where you want to set that out very clearly so that both parties are on the same page.
I'll talk about this more in the IP section, but this is another thing that does come up quite frequently. I had a new file come in just the other day where it was exactly this issue, a dispute over ownership of IP.
Yeah, we'll be covering a little bit more in intellectual property section. So I did promise I'd talk more about shareholder agreements, and I want to highlight here that shareholder agreements, I think, are probably the single most important agreement your business needs right at the beginning. Without one, if your business takes off, it can be really a nightmare to deal with disputes. If you need some real life examples, just watch the movie The Social Network. It'll give you some some good reasons as to why you want to have a really clear agreement between the founders. And also, a key consideration for any business involving multiple owners is to ensure that expectations, responsibilities, rights, and restrictions for each owner are clearly defined and that they're properly drafted in this sort of agreement. So you do want to take this sort of seriously early on, and that's the best part of running a business is, when you're in that phase where everyone seems to be working well together, is to sort of make sure everyone's on the same page, because ultimately that's going to serve you well when things may not go the way you expected. And, money changes a lot of things. So if you suddenly get a lot of investments, or if your app that you're developing takes off, then this is really the point of contention that a lot of founders experience. So this is why we try and emphasize it. All right. So when you're experiencing growth and you're looking to fundraise, either from third-party investors, friends or family, etc., we often recommend a term sheet along with something called a subscription agreement. And this is really an essential agreement to ensure appropriate compliance with securities laws. Generally speaking, and a lot of you might already know this if you've attended some of the other sessions put on by other law firms today, you cannot solicit investments from random individuals. You want to make sure that they're qualified investors. So either they're specifically friends, family, or business associates, and they're sort of defined in the securities legislation as to what those constitute. So it can just be someone that you consider a friend. It has to be something that's legitimate, as well as certain high net worth individuals, or as they're known in the legislation, accredited investors. So this is really important, and this is why we want to emphasize this. The other types of agreements we list here are generally decided on a case-by-case basis. But the purpose that I want to list them here are for you to speak with your legal counsel early on, before engaging on any major transaction, to ensure that you receive appropriate legal advice and that appropriate considerations are taken into account. So this may come into place, for example, when you're expanding and you want to involve a third party to distribute your products. This is where distribution comes into play. Or perhaps you're now at the stage where you're trying to sell your business. This is where a share purchase or an asset purchase agreement might come into place. So really, these are sort of key transaction documents that, as you experience the growth or are looking to exit, that's where you need proper legal advice, and you want to start that discussion early on with your legal counsel. All right. Finally, I want to mention here that regardless of the nature of the agreement, a poorly drafted agreement can actually cause more headaches than it's worth. Not to mention the potentially hours of litigation should interpretation of the agreement come into question. This is why non-lawyer drafted agreements may seem convenient or even very inexpensive to do so, but may ultimately either not be enforceable or may be causing confusion or a point of contention, which can only be resolved by spending a lot of money on legal fees. So, Cam, do you want to mention your recent experience about this?
Yeah. We do see this a lot. Actually, one thing I often see is people come in with agreements they've drafted themselves or they found online. I'm thinking that it might save money given that there's already some text on the paper. Most of the time, it's actually cheaper to start from scratch because we already have precedents for most types of documents. So and I know we've been throwing out a lot of different types of agreements and documents you might need, but a very short conversation with a lawyer can narrow down what documents you actually need. Some might be worth having, but many might not be worth the cost. So, a pretty quick conversation can narrow it down to what's actually necessary. But I think it's just worth considering, depending on the type of your business, it's worth knowing what types of agreements you actually do need.
And I will mention that even if the agreement is drafted by a lawyer, it may not necessarily be a good agreement. The key things you want to look out for are that it's formatted clearly, uses concise language when possible, and not legalese. Legalese basically means mumbo jumbo that a lot of people just gloss over. And the whole point of an agreement, and where it really serves the purpose that it's intended for, is where both parties are clear and understand its meaning. So if it's very convoluted, it doesn't serve anyone, and essentially it's not doing its job. So it really should contain defined terms if it's a longer agreement, it should have a separate section where there's definitions, for example, and those defined terms should be consistently used throughout the agreement. I've seen in my practice of reviewing agreements for the last more than 8 years, tons of agreements that come to us where, either there's definitions that are not used, or there's terms that are used that are not defined anywhere, and this becomes very, very difficult to interpret at the end of the day. So it is something that you do want to pay attention to. I guess now's a good time to hand it over to my colleague for the next few slides to talk about intellectual property protections.
Sure. Thanks, Anand. Before we do, I see we have a question. I think we'll just take a little break from the slides and I'll answer the question. So someone asked if they're using an independent contractor model, are there any specific agreements they should be thinking through? So if you have an independent contractor, you should have an independent contractor agreement. You mentioned Uber in the question. There, in circumstances like that, there can be a legal question as to whether the person is truly a contractor or an employee. And legally, there's a pretty significant difference. Unfortunately, how you characterize them in a document doesn't necessarily mean that's what they actually are. So you could call someone a contractor, but if their duties are like employment duties, and if they come into an office and work 40 hours a week for you, even if you call them a contractor, they would still be an employee. But in either event, you either want to have an employment agreement or an independent contractor agreement in place. For an employee, you can limit your liability for common law severance in an employment agreement. So that's a very good reason to have one in that context. For independent contractors, a key thing, especially for startups, is intellectual property ownership, which I'll get to in just a minute. Is there a place that lists the difference between employees or contractors? I think so. Courts consider a whole bunch of factors. And in general, someone who comes to a particular place of work, works for a person full time, does not provide their own equipment, those are factors that indicate that someone's an employee. If someone has many different clients, if they don't work full time for someone, if they bring their own tools, if they have control over the way they do the job, that indicates that the person is more of an independent contractor.
I will mention that there's literally hundreds of cases out there that sort of try and distinguish where, the employer might want to make a person, considered one or another. And basically it's a question of mixed fact and law. So, it's not always straightforward, especially with certain professions. So, if you're a professional or other types of individuals, and, a real life example of that is Uber, for example, right? Where they're trying to classify their drivers as independent contractors, but courts in California have recently said that they're more considered employees. So, it is something that is a live issue that, often is not something that, we'll try and advise you on, but ultimately can only be decided by a court of law if it becomes an issue.
Yeah.
All right, why don't you go ahead?
So I'll be discussing the four main types of intellectual property. Those are trademarks, copyright, trade secrets, and patents. So I'll start with trademarks because every business will have a trademark. Even if you think you don't have a trademark, you do. because any word or symbol you use in association with the sale of a product or service is a trademark. Now, if you don't have a trademark registration, it is an unregistered trademark. An unregistered trademark does provide you with legal rights, but they're more limited than a registered trademark. They're limited in that they only apply in the areas in which you've actually used the trademark. So if you have a business in Richmond and you've been using your trademark there, you have certain protections for the use of whatever the term is in Richmond, but you don't have any protection in Calgary. If you get a registered trademark, you have protection all across Canada. So that's one of the key reasons to apply for a trademark registration. In terms of choosing what word you should use for your business name, the two important factors are, one is you want to have a distinctive name, and two is you want to make sure your trademark isn't already in use. So by distinctive, I mean your trademark should not just be a description of what you're doing. So if you have a cookie store, you shouldn't call your business the cookie store, because generally under trademark law, a term that's generic, that just describes something and doesn't have a distinctive element, gives you very little trademark protection. If a competitor wants to open a store called the cookie store, you might not be able to prevent them from doing that. So you might want to add a distinctive element like Galaxy cookie store. That word Galaxy is distinctive, so someone else would not be able to use the term Galaxy cookie store. Second consideration is you want to make sure your trademark isn't being used by someone else already. And this comes up all the time. Someone has started a business, they think they have a really good name, but 6 months into it, they discover that someone else is using the exact same name in another area. So to prevent that, you can do a search of a trademark database. There's other types of searches you can do. A lawyer can help with it. Even just a comprehensive Google search is better than nothing. So that I think is a pretty key thing to consider when you're starting your business.
One thing I just want to mention here is domain names. So people often come to us saying that, they have this great domain name and they think, it can be trademarked, and often they're mistaken. So a domain name is separate from a trademark. You may have a great domain name, but it may not be something you could trademark, or vice versa. You may have a great trademark, but the domain name's already taken. So it is something you want to factor in as well in this day and age, especially if you're in the tech space, which most of you are. So
yeah, that's a really good point. Yeah, domain names are distinct, and so are business names. So if you have a company called XYZ Incorporated, that doesn't prevent someone else from using that term XYZ. It only prevents them from having a company name that's identical, XYZ Incorporated. So really the best form of protection is having a registered trademark. Actually, can we flip to the next slide?
Yeah.
Okay, well, I didn't mention it, but just for context, a trademark application is relatively cheap. The process might cost $2,000 or $3,000. It's on a country-by-country basis, so if you want a trademark in Canada or the United States, you have to apply in each of those jurisdictions. Second form of IP I want to talk about is patents. So patents are granted for inventions that are new and non-obvious. And as you can see on the slide, each of those terms is in scare quotes because each has a legal definition. An invention is sometimes characterized as a technical solution to a technical problem. So things like a artistic technique or a recipe that isn't a technological thing generally can't be protected by a patent. It has to be new, so your technology can't have been known to anyone anywhere in the world, and that includes disclosures by yourself. So if you publish something on your website and a couple years later you decide you want to apply for a patent, you'll probably be out of luck, because at that point, because you've published it, it will no longer be new. So if you're disclosing to anyone before you've made that first patent application, you should be secretive about what your technology is. And for anyone you do disclose it to, you should have a non-disclosure agreement in place. Some countries have grace periods where if you disclose the technology, you have 6 months or 1 year to apply for a patent. But many countries don't. As soon as it becomes in the public domain, you can no longer apply for a patent. The final factor is it has to be non-obvious. So it can't be an obvious combination of some existing technology. So, if drone has been invented and a camera has been invented, you can't get a patent for just putting a camera on a drone because that is an obvious combination of existing technologies. Once you get a patent, you have a monopoly on that technology for 20 years, which is a pretty significant amount of time. And of course, in that 20 years, you don't have to worry about any competition for someone selling the same technology. Patents are on a country-by-country basis. So if it's worthwhile patenting something in one country, it's often worthwhile doing it in others. So you might need a patent in Canada, the United States, and any other country where you might be manufacturing or selling the product. And patents are a bit harder to get than trademarks. It can take, I say here, 2 to 4 years. It can cost, a few tens of thousands of dollars to get a patent. And if you're going to go for patents in many countries around the world, the cost can be very high. Fortunately, there's ways to defer a lot of those costs. So you can file a patent application for relatively low cost. And throughout the process, over those 4 years it takes to actually get the patent, you're incurring more costs as you go along. But before that happens, you can decide how viable the product is and whether it's worth spending more money on this thing. So don't let there be too much sticker shock there because you can defer a lot of the costs. Oh, I have a trademark question here.
Yeah, if you've been using a brand name for a few years, another company registers the brand name legally, can they stop you from using that brand name even though you've been using it before the company?
So this is a question about basically who has rights in a trademark when one entity was the first company to register the trademark, but the other company was the first one to actually start using it. Canada has a first to file system, so the first entity to file the trademark generally has the rights to it. The entity that's been using it may retain rights to use it in a specific geographic area where they've been using it, but the company that registered the trademark would get to use it everywhere else in Canada. So it just emphasizes the importance of registering early if you're planning on using a particular term.
Right.
Yeah, in the United States, it's the same. So it's pretty much no matter where you are, it's very important to file early. Otherwise, if someone jumps in and files, even if you've been using the name before them, it can cause problems. Next form of intellectual property protection is trade secrets. Now, trade secrets technically isn't really a form of IP protection. It literally is just keeping a technology secret. Now, for some types of technologies, this isn't practical. If it's a product you're selling to the public and they can easily take it apart and see how it works, you obviously can't have a trade secret. But for some things, certain types of source code, recipes, manufacturing processes, those you can keep secret. And to the extent you can keep it secret, it's a good alternative to patenting the technology. If you patent it, you have to publicly disclose it. Patent applications are public. But if you can keep it secret, you have protection that lasts forever. If no one knows how to do the thing you're doing, then they can't do it. So yeah, the advantages are it's free, it lasts forever, you don't have to apply. The disadvantage is if it ever leaks, if it ever is disclosed, even by some illicit means, if you have a rogue employee or there's some accident where it gets disclosed, you do lose that. It no longer is a secret, so now your competitors can't start using that form of technology. But for many startups where the source code is one of their key forms of IP, using a trade secret rather than trying to apply for a patent is often a good route.
Yeah, and I will mention that, yeah, once the cat's out of the bag, it's sort of hard to, in fact, it'll be almost impossible to take away the secret. So that's why this protection is sort of more of a, beware and and acknowledge the risks.
Yeah, in some circumstances, it could be a tough call as to whether to apply for a patent or to try to keep something as a trade secret. But it would be on a case-by-case basis. Finally, copyright is the final form of intellectual property. Copyright protects literary, dramatic, musical, and artistic works. It arises automatically upon creation, so you don't need to register it. You can register, but it only provides very limited benefit. It's very cheap and easy to do, but it isn't strictly necessary. So the author is the initial owner. The minute the author, if you write a poem right now, the second you put your pen down, it will be protected by copyright. And copyright prevents anyone else from copying exactly or close to exactly the thing that you've created for the remainder of the author's life plus 50 years. So it's a very long period of protection. Copyright does apply to software, which is sort of a bit strange. You know, when the concept of copyright was originally created, I don't think anyone was anticipating software, but it is protected by copyright now. It's a quite limited form of protection, so it prevents someone from copying and pasting exactly the same code that you're using, but it doesn't prevent someone from writing code that does substantially the same thing, but using a different implementation. So that said, it can be quite difficult to get patents for software, so copyright ends up often being the de facto form of protection for software. Now, just a general point about IP is if you have employees, any intellectual property that they create for you, in general, if they create it in the course of their employment duties, it is owned by the employer automatically. Now, you'd want to confirm this in an employment agreement, but that's the general rule. Anything created by an independent contractor, the IP can either be owned by the contractor and have a license to whoever hired them, or the IP can be owned by whoever hired them, and it depends on the term of the contract. And if there is no written contract, that's where you can end up with big disputes. I have one going on right now, where it's just not clear who actually owns the IP. So anytime you're hiring someone to create things, to invent things, to generate any type of work product that has IP, oh look, my lights went off. It's energy efficient automatic lights here. But anytime you have someone creating IP for you, it's very important to have a contract that clearly says who owns the IP at issue.
Yeah, thanks, Cam. All right, before we end off tonight, I just want to talk about something that, often a lot of entrepreneurs will struggle with is how to choose the right lawyer, how to find a lawyer, and how do you go about doing the proper research. So I put together a couple of different suggestions here as to things that you can look out for. Now, last year when I presented this slide, there were a couple of questions as to what sort of are the fees for certain things, and it's sort of got us thinking that clients that come to us sometimes resort to using poorly drafted or boilerplate agreements from just searching Google, and really that's and I think you agree with this, Cam, that it's a terrible way to really protect yourself, because you're doing yourself a disservice. Like I said, a poorly drafted agreement is just going to cause more pain and suffering than one that's actually done properly from the get-go. So knowing these pitfalls and the issues we see when when clients use these sorts of agreements, we recently launched a new service, and that's the next slide here, and it's called WG Direct. WG obviously stands for Watson Goepel, our firm name, and the direct portion of that is specifically it's targeting entrepreneurs, startups, and basically any small business that you're getting access to legal documents drafted by our own lawyers, but at affordable and fixed fees. So this is a great alternative to many other no-name or unknown service providers that exist online, because this is literally law firm generated documents, and it involves a 3-step process in terms of getting whatever you need. So like I put here, the website is wgdirect.ca. And if you go on the website, you'll see that it offers a variety of services such as discounted incorporations. And that's my next slide here. So, you'll get access to things like a discounted incorporation. And I will mention a lot of clients come to us where they've incorporated on BC Online, which is obviously the governmental entity that operates the incorporation service, but that's only, you're basically 25% there in terms of creating the incorporated entity, because there's a bunch of documents that are missing that's typically contained in a corporate minute book. So with our service, you'll actually get a full minute book package. For example, the organizational resolutions, the Social Securities Register, all the things your accountant or other investors will definitely be looking for. And if you don't have those done properly, you can often run into issues, and it'll cost more to fix than if you just did it through a lawyer the first time. We also offer basic will startup documents as well. So a lot of the startup documents we talked about today, employment agreements, independent contractor agreements, shareholder agreements, we provide, sort of general precedents for you, that are annotated for you to play around with. We obviously provide customization services, also at a discounted fee. And this is really to lower the barrier of entry here. And I think what we're trying to do is to say that, we'd rather you spend, time looking at a service like this rather than just trying to do it on your own and trying to figure out, is this an American agreement that may or may not work in Canada and British Columbia? And really, that's sort of the value proposition here, is that it is backed by a law firm, and you will be responded to from other lawyers at our firm. So it's simple to sign up. We have intake forms on our website for each of the services we provide, and you can even save the form and come back later if you want to have more time to complete to sign up for the service. So really, it's we try and make it as easy as possible. That's not to say it replaces legal advice. So we do encourage you to seek out, if you have existing lawyers, obviously talk to them. But if you're looking for something completely different, then it's a service that we can provide to you. And yeah, I guess that's the end of our presentation here. We'll take some questions here. And I think the first question is there a discount for VSW attendees? Yeah, I mean, the pricing we listed on there is actually for this event. So it was recently launched, and it's targeted for entrepreneurs like yourselves. So definitely take advantage of that because the prices may change in future.
Great, thank you. Well, first of all, I'd like to thank the presenters, and I'd like to thank all the attendees for joining this session. I'd also like to thank everyone who's involved with VSW 2020. This is our last session, so I hope you had an amazing time. I invite you to visit the Watson Goepel booth in the expo area if you'd like to learn more, or if you'd like to get in touch with them. You can go there by clicking Expo on the left-hand side of your screen. Hop-in will remain live for a couple hours, so you have time to check out all the booths in the expo area, and of course visit the main stage for our final house party event. A friendly reminder that the VSW Recruitment Fair is also happening tomorrow, so if you're interested in exploring any employment opportunities, don't forget to stop by. And with that, thanks again, and hope you enjoyed Vancouver Startup Week 2020.
Thanks, David.
Thanks, Jaden. Yeah.
Thank you.
Thanks for everyone that give us an opportunity to present today, and we'll look forward to hopefully hearing from some of you.
Now, if people have questions, if you want to ask any questions, can we stick around and answer them?
Yeah, absolutely.
Okay. So feel free to type into the chat if you have any questions.
Yeah, if you have any questions on
any topic.
This is your time to get free legal advice. I will.
Thank you, guys.
Yeah, thanks. Thanks, Jaden.
I believe the house party or the DJ party is happening right now.
Yeah, so, I mean, legal topics versus a dance party. I think the clear winner is legal, but
Okay. Oh, we have a question. Okay. Product IP.
Okay, go ahead.
Just is a bit more clarification. How do you mean product IP? Okay, maybe I'll wait for the clarification on the IP question, but in the meantime.
Yeah, let's answer the other one. I'll take that one. Advice for those who have incorporated with BC and federal government but want to restructure shares from one class to many. So, yeah, I mean, if you've done an incorporation already and you realize that, when you're talking to investors, they want a particular class of shares that, obviously didn't exist at the time they incorporated, it's definitely possible to file something called Articles of Amendment. And this is where the assistance of a lawyer is thoroughly recommended, because we'll help you with sort of taking your existing incorporation, making sure that all the documents are in order up to the current date, and basically filing whatever is necessary to implement the changes that's been requested. So, for example, a lot of companies that come to us will just have a single class of common shares, but investors will be looking for, a preferred class of shares that have a dividend rate that's set right there. And that's something we often help with. And, it's relatively inexpensive in terms of the grand scheme of things. So it's definitely worth checking into. And you don't need to incorporate a different entity just to fix your share structure. Okay.
In terms of the IP question, it was about a manufacturer making a product that isn't necessarily new, but the process is unique. So yeah, you can get a patent for a process to create an existing product. If the process is somehow unique and better than existing processes, that is something that is potentially patentable. You have to do a prior art search generally before submitting a patent application, so you can search existing patent databases to make sure it is a unique process. But assuming it is, and assuming that it's not an obvious combination of existing technologies, then you should be able to get a patent for it.
The next question here is, I'd love to hear your advice on data ownership for a tech startup. So yeah, I think we covered a little bit about this, but the key emphasis is, if you're hiring a third party to develop either the software or the product or the app, you want to make sure that you have a strong agreement with that party, because that's where you're going to be putting in that any intellectual property rights that that person who's developing the app or software, et cetera, they basically assign it to you. And this is what investors, if you're fundraising, will be looking for. If you don't have that in place, then it becomes a gray area. They're very unlikely to provide you, the investment you're seeking, because basically, if your whole product is centered around, this particular, if your whole business is centered around this particular product that you're trying to sell, but there's no clear chain of ownership in terms of how the intellectual property is owned by your company, then that can definitely pose a problem. So this is why you want to have, if you're having a service agreement, that is right in there. And ultimately, if it is something that's patentable or something that you want to trademark, it is something that we definitely encourage. And this is where, you could seek the advice of a professional to guide you on the different options.
More on the IP question. If you have a patent for a process, it means no one else can use that process during the term of the patent. Patent protection is relatively narrow, so it depends on the patent application that's ultimately granted. But generally, protection is narrower than most people think. So if someone modifies your process sufficiently, then they wouldn't be prohibited from doing that. It has to be quite specific to what's disclosed in your patent application. In terms of the question, is it preferable to have employees or contractors? It really depends. When you have employees, it means you have to make statutory remittances for tax, CPP, EI. I think it's generally a bit more difficult to deal with employees. With a contractor, you just write them a check and that's it. With employees, you have more responsibilities. And from the perspective of the person that's being hired, sometimes they might prefer to be a contractor because that way you can write off expenses. There are certain advantages, but it depends on the circumstances.
And really, you might not have a choice. So, for example, if it's someone that's basically working for only you or your business, and you want to treat them like an independent contractor, that's going to be almost, you might want them as an independent contractor, but that might not be legally possible. So it is something you want to make sure that it's feasible, because like we mentioned before, there are a lot of factors that courts have considered in terms of what's more likely. Is this person an independent contractor or an employee? And, despite whatever the employer wants, it might not be possible. So it's something that you want to get some advice on, if that's a question.
It can be dangerous. I mean, if you hired someone to come to your office and work for 40 hours a week, they would be an employee. But if you said, I consider them to be a contractor, I'm paying them as a contractor, If they don't pay their own income taxes, the CRA could come to you as the employer and say, hey, this person was actually an employee. Where are all the tax remittances? And they could go after you as the employer for those amounts. So it's something you want to be careful about.
Next question here is, how much does it cost on average for lawyers to look over an agreement by a third party? I mean, that's a very difficult question because it sort of depends on the length of agreement, the type of agreement, the complexity. But I will mention that one of the services that are on the website is sort of a free 15-minute consultation. And again, that's intended for the audience that we're presenting towards today. So I don't know how long that will be available for, but the point is that if it's something that you have in place but you just want to get an estimate, we're very at least both Cameron and I are very upfront in terms of what we generally do and charge. So if we're talking about a simple employment agreement that you're looking to get reviewed, it may cost as low as a couple hundred, but if it's something like you're drafting an agreement from scratch, then that might be a little bit more. So it sort of depends on the complexity and the type of agreement we're dealing with.
There's a question, what if you're wanting to collect data from consumers with a hardware product? So if you're collecting personal information from anyone, you need to be in compliance with the Personal Information Protection Act, which is legislation in BC covering how people's personal information is dealt with. It's relatively strict. You need to disclose a lot of things to the person. You have to disclose how you're storing the information, what you're using it for. You need their consent for certain things. So it is something you want to be careful about. Personal information is people's name, age, address, any sort of financial information, those types of things. It's best practice to have a privacy policy in place that discloses to the people that are providing the information what you're going to be doing with it. If you have a website, you can post it on your website. But that's an area where you do want to be careful.
While we're waiting for the next question, I just want to reiterate what I said about incorporation. So a lot of startups come to us, saying that they've self-incorporated and then one is to fix it. And often the cost of fixing that incorporation costs more than if we incorporate it from the get-go. So I highly encourage you to consult with a lawyer and your accountant before you decide to incorporate, because it could have impact on, once your business picks up. It might work for you in the beginning, but very soon you might find out that you might need to restructure things and it'll cost more to do so. So try not to skimp on things like that. And definitely with the shareholders agreement, I think I've sort of emphasized that as well during your presentation, that it's something you want to take seriously and try and iron out early on, because last thing you want is, to spend tens of thousands of dollars trying to fix any mistakes.
The person clarified their question. They say it's not personal information. So personal information is a defined term under the legislation. So you might want to check to make sure that it isn't actually personal information. I'm trying to think of an example of what wouldn't be. I don't know if it's sort of a video game, you're keeping track of people's high scores, that may not be considered personal information. But if it's not, then that particular piece of legislation doesn't apply. But you want to make sure that it's not. Yeah, sensor data. Yeah, I mean, if it's unless it's something that can be used to identify a person. So I mean,
if it's aggregate data, it's not really an issue.
Yeah, if it's GPS data, that could count as personal information. So you'd want to just look and make sure that it isn't actually personal information.
Any other questions?
Well, I think it's 7:20. Might be time to head over to the disco party.
All right, we'll just give it a little minute here. Any other questions? Sure, we'll look forward to seeing you there. Thanks. All right, yeah, if anyone wants to get in touch with us, you can find us on watsongoepel.com or on this website, wdirect.ca, and just let us know and we'll get in touch with you. We'll also provide our email right here. And if you visit our booth, you can also chat with us over there as well. Thanks, everyone, and have a great night.